All right. So, scope of this meeting, we're talking specifically about search and seizure legislation. Is that right?
Mm-hmm.
Okay. All right. So, how is this formatted? Are we going to bring up, things that we see that would like change or that need adjusting? How do you want this meeting ran?
So this is kind of just like your guys' opportunity to bring up concerns to us of what you guys would like to see in it or what you'd like to see changed.
Okay.
Fair enough. Well, I'll start off then with SIM cards, specifically in the search and seizure legislation.
This is the new one that's posted, right?
Yes.
Yeah, I just publicly shared it on the MDT so that if you guys want to take a quick look at it, and it'll be right there.
Yeah,
Easy.
I believe it's going to be Article 1, Section 4. I'm sorry. Article 1, Section A4, which is specifically covering SIM cards when it comes to phones. Now, obviously, in the past, we've established across the board that the DOJ want the PD to be filing search warrants to receive or to view that phone number, which is printed on SIM cards. We're hoping we get something along the lines, instead of having to seize that phone, hold on to it pending the outcome of that search warrant to get that SIM card out of there. We're hoping we can get something in legislation that would allow us, in the event of which we are going to be pursuing a subpoena on a phone, that we are able to strictly view the phone number on the SIM card in a phone, so we don't have to seize it from someone.
So you have someone in custody. You have the intention of subpoenaing their phone records. You want to be able to see what that phone number is that is in their possession, because you have not. I would even go as far as saying, like, listen, if someone's, yeah, that makes sense. You want that even if you don't know if you're going to subpoena it yet, right?
Right. I kind of look at it similar to how, it currently stands with properties. We lock down properties when we have the intent and we are writing that search warrant, that search warrant for a property. When it comes to the phone, we're hoping to get something in writing that allows us to just collect that evidence to further then go into a subpoena. I'm adding the added aspect of our intent is to file the subpoena, so it does not get abused. If we're taking that phone number, we should be going for a subpoena. We shouldn't be going through the SIM card slot without that intent.
Yeah, I mean, essentially the way that it's interpreted right now is the PD's kind of in a bind where they're essentially have to get a document that has a higher legal burden.
I can't shut off my fucking stream right now.
A subpoena through, which has a much lower burden of proof to overcome. So it's just
my Twitch stream
a bit odd, and it's not really easy for officers to manage and handle.
Wait, it says my stream is off. Oh wait, there it is. It did work. It was just scuffed.
My perspective on it is, I would imagine, just in my opinion, and in my experience when I've seen these before, when you write up a subpoena for the information you want to obtain that is in the phone, using the same probable
You're all
cause
cute.
in that subpoena for, hey, can we just look at the phone number on the SIM card, would I don't imagine that would be anywhere different, honestly, of a bar than to get the information that is in the phone. If anything, it would be a lesser standard to get just the phone number on the SIM card.
What may I ask, why is the phone not taken?
Well, that's what they were saying they want to avoid. They want to avoid seizing the phone.
No,
but yeah,
we absolutely seize the phone. Yeah, that's what we do currently, is we seize the phone. We're trying to avoid the seizure of a phone. If a search warrant takes 12 hours, or not search warrant, subpoena takes 12 hours to get fulfilled, that means we have.
You don't want to deprive someone of a phone.
Correct.
In the, yeah, that makes sense.
Be as least restrictive as possible, basically.
So you're essentially saying there, Danielson, one subpoena would be sufficient for both, but we don't even have a number to say we're going after at that point, right?
Negative. You would use the same probable cause on both subpoena. Just
Well-
articulating that you want the phone number on the SIM card. We'd grant that, and then you'd submit the same subpoena with the phone number.
If I may, Your Honor, in the interest of, I think we should also think of this from a process standpoint, because essentially we're in a position where we can make the process a bit more streamlined and make it kind of easier for everyone, judges including, going forward. Essentially, the standard that you want is we would have to write a search warrant, send it to you. You would then have to take the administrative time to go for it, review it, send it back. Then we would write up another subpoena, send it back to you to be signed. When we could alternatively put forward a relatively easy modification to do to legislation that's already potentially being reworked and kind of save us that administrative pain in the
Yeah, but
dick,
we have to
you know what I
think
mean?
about
'Cause
people's
the
right
end
to
result is the same.
property.
You're right, but it could also just be a little bit easier on everyone involved in the process.
Yeah, but we have to
I understand. I just come from a standpoint of
the evaluation.
writing something in like that just to make it easier.
Yeah.
I would want, like, it's a little difficult to just stand on that, if that makes sense.
I suppose so. I can understand why you would be hesitant to change it around for that.
That's what
I get
needs
that.
to be balanced here.
I'm not against it. I'm stating my concern.
I just think that the number that a phone has is, in my opinion, I know the law states it's protected or it could be interpreted to be protected information. I don't think your phone number is protected information.
It
It's
is
just
because every
a
phone is a
number
burner.
that people can use to contact you.
Oh, Lord
right?
have
Like
mercy.
the information within your
Chat
phone
in
is
real.
protected.
Imagine
like your
that
texts and
was
your
in real
calls and all
life.
that
That's
stuff,
how it worked.
But you know, it's basically public information, arguably, considering
It's
that we
not.
post our phone numbers for people to contact us at any time, right?
Well, so that's not so much the argument that I'm making. The argument I'm making is, as the legislation stands currently, to open the back of someone's phone is opening a container, which
Yeah.
across the board, you cannot open a container without a search warrant.
Sure.
So I want to restate, I'm not against the amendment. I just want to make sure that we go about
Yeah.
it the right way so that it's not too
Yeah,
open
doing
to
it-
interpretation.
Yeah, doing it the right way is proper, of course.
So let me throw up a quick a possible solution with an example. We arrest someone for, say, some sort of violent felony. We
That's why
believe
you
we have
can't
probable
just-
cause for it. We take them down to the cells. We start processing them. We process their DNA, fingerprints, and everything. Right? It comes out that this person's innocent before we finish processing. We say, you know what? Further evidence has come forth. We have further statements. We are not going to be pushing these charges. You're going to be getting a misdemeanor instead of a violent felony. So we lower those charges. Now we don't have grounds for DNA. We take that DNA, we dispose of it. There could be that protection in place that, say we don't go for that subpoena. We had the intent, a good faith intent, to go for that subpoena. As soon as that subpoena is no longer being fulfilled or we're no longer pursuing it, we are then to dispose of that number.
How do you know it's going to be disposed?
I'm not really against that, but I'll let Falconer talk.
Yeah, I think that could work. I think maybe in terms of like the line that we're talking about, to change it to fit what's desired right now, it could just say, digital contents of a phone shall be considered personal property protected by the Constitution.
Right. I hate to say this because I'm not in this position anymore, but when this was written, the intention of that line was specifically to protect people's contents of their phone. It wasn't necessarily designed to stop you from knowing what their phone number was, right? So I'm essentially trying to get us to correct the mistake of the past in this particular instance.
I know the arguments that's been brought up before is the definition between contents and data. I don't know if that's going too deep or not, but the contents were perceived as anything therein of that object, whereas data was the data on the phone. So I know that's how it's been argued before.
Yeah.
I brought the same thing up before, essentially.
I will say with what Falconer's saying, changing it from just contents to digital contents, I think would cover that base. So it allows you to just open the phone to check the phone number, but anything digitally that is in the phone, you can't just swipe through it.
Yeah, I would agree with that. I think that's a pretty common sense change. I don't know what you think, Tony.
I think that's fair. Peters, Nino.
Yeah, I think we need to have a way to access phone numbers rather quickly. Especially, I think everything in Los Santos moves very fast, and to have to subpoena a number as well, and then wait for that to get approved to something else as well as something else, and anything to make our lives easier. Obviously, we don't want to like exploit people's privacies, but at a point, we do need information fast to us. So.
I mean, it also makes it less restrictive for the person that we're, for the suspect. Essentially, we're not withholding their phone for them for several hours while we're waiting for the first search warrant to go through, to get the phone number, because we can get the phone number easily, and then
This is gonna get
and then
abused.
they can have their phone.
I guarantee it.
Fine.
Yeah, I'm not necessarily opposed to it. I think there does need to be a line in there in which the documentation of said phone number is restricted to the subpoena that's being written, and it would be illegal to do anything beyond that. I'm gonna give a bit of a opposing opinion to some of the conversation so far, and I think what we're weighing here ultimately is the rights of a person, their property, and whatnot. A phone number, while San Andreas works very differently from the rest of the world, so that is something that I think I am keeping in mind with this. Are these burner phones? Are they issued? Who's the cell phone company? A lot of these things are inherently undefined. Take for example, New York, right? If you go pick up a phone over at like CVS or something like that, one of those disposables, that number is not attached to any one individual. I mean, unless there's a state law, which we're not going to get into. My point here is that you are opening someone's thing up and you are looking at it. So we're taking away some of their rights for the greater good in this case, and we need to make sure that that privilege that is being given out is not abused. And is that something that y'all would be comfortable with? Is that you have the ability to look at that phone in the case you're writing a subpoena, but that phone number's recording can only be as far as that subpoena, unless that subpoena goes through. So in other words, there would not be a report created. There would not be some external note made.
Would that be contingent on like the successful approval of a subpoena? So if it was denied, then we would have to delete the information. Is that what you're saying? Or
Exactly that. So if it was denied, but there should be still some room for you to be able to resubmit it. So in the window,
we do the same for DNA. I don't see why. I personally don't have an issue with that.
Yeah. Okay. I think that's reasonable.
I would agree I'd agree as well. I mean, at the moment though that it's been approved, at that point, then it's evidence, right? It's part of that case, and it can't be utilized, right?
Yeah, and we do the same thing for DNA. So, right, in the interest of expediency, we can collect someone's DNA and then wipe it if it turned out to be incorrectly to do so. You know.
So I guess my question there, from your point of view, Nino, that subpoena goes through and gets approved. Are we now able to associate that number with, say, someone's specific profile?
I would think so, yeah. Because I mean, at that point, it's you'd be sharing it like throughout the department, right? So whatever your internal documents are, I think that's within reason.
Okay, and what's the DOJ stance on it so far?
All that sounds reasonable. To go on with something what Nino said, in our state, it's possible to subpoena who owns a phone number if they bought the SIM card with their bank, or it was the one they were given when they phoned in.
Wait, there is a way?
Yes.
I see.
we have been told by the IT people, you know, if they buy it in cash, there's no record, there's no name attached to a SIM card. But if you buy it with a bank card, then it's attached.
Has there been? I don't want to go too deep beyond the scope of this, but I do think it's relevant. Have there been any guidance as to who the phone company is? It was a certain way 6 years ago, where there was a phone company, and you know,
not really. We've just been, because I think the marshals did a subpoena to see who owns a certain number.
right?
I think it was the marshals, I recall.
I think it was Marshals.
And
They've
we
done
were
a lot of
told,
those.
yeah, we were told if they flew in with it, or it's purchased from Click Levels with a bank card, then it, you know, there's a record of it with the name attached. But if it's cash, then it's nameless.
Do you think that phone company or the IT guys or whatever, if someone were to, let's say, you know, Bobby Smith was under investigation, would the PD be able to receive all phone numbers associated with said individual if they had the probable cause? Or are we talking a very hard, like,
yet.
okay.
I think that's how it was pulled, though, if I remember right.
Yeah. It makes
it's kind
sense
of
for
like-
that to happen. I don't know what the difficulty on the other end would be, you know, by phone
Yeah, I
IT
think-
services.
I think something like that ends up getting pulled, kind of like how, sort of like a bank record. I'm trying to remember because this was a while back, but I think that was how that was pulled. That information, we felt like they were able to see who has what numbers. Like if this person bought so many SIM cards, what numbers did they buy with card, or what do they fly in with?
Yep.
But I will say, from when I've spoken with the IT guys, they are more than willing to fulfill anything that's possible, as long as there's a good reason for it. So if it's possible, they'll do it, but there has to be a good reason.
Brian has definitely opened up people's phones, by the way, and taken a photo of it 100 times over.
That makes sense.
I am glad I am here, by the way.
All right. Was there anything else SIM card related that we want to touch on? Anyone?
No, I believe that's the only thing that we had for that in my notes.
Okay.
So I have it written down as the addition to digital content for.
Well, I'm mostly here because I was astonished by
phone and their digital
its
content
public
shall be
information
considered
and stuff.
personal
It's
property
not. It
protected by the
literally
Constitution
isn't.
of San Andreas. And then a subsection below that, I didn't have it formally written out, but it just has hinges on the subpoena being approved. Otherwise, the information.
Yeah, because cell phones aren't landlines.
And then later on, we can flesh that out into an appropriate line. But I just have the general idea written down so I don't forget it.
Is there a world where somebody argues that the phone number is digital content, even though it's
no, it's
written
physically
on the SIM card? Okay, just want to make sure.
Nino needed an enemy? Are you autistic, bro? Like, what the fuck?
On the SIM card.
Get the fuck out of here with that dumb shit.
Sounds good to me.
Yeah, sounds good.
So, I briefly went
Control
down,
that shit,
I
bro.
went through this search and seizure legislation.
Yeah, this is an
just a few
open
things that I
season
have
to
notes
say
on
weird
here,
shit in
I
chat.
think a few people have notes I want to talk about. I guess it's more towards the DOJ. Magistrates, are they allowed to sign search warrants?
Only if a
Justice
justice gives
approval.
them permission, yeah.
Okay, can we get that updated on the legislation, or is that covered under another legislation?
It's covered under the judicial powers.
Homie's the kind
Could
of dude that likes to
highlight the
get
line?
butt
'Cause
fucked and be
I,
like,
I've been struggling to find
the
it
other
in
person
here.
had the right to do it. You know what I'm saying? Damn,
The
that's
judicial
crazy.
powers legislation. I haven't been able to find it.
So it's at the end of the magistrate list. It says other powers. Then the second sentence is justices may also assign additional responsibilities to magistrates provided they are documented. So you know, if
Oh,
like
I see. Yeah.
yeah.
Okay. Yeah, there it is. That's right. Yeah.
we use those as like let's say like a low stakes, I don't know, like a book subpoena or something comes in, we might let a magistrate look over that to with our oversight to help train them and
The
on way to
book is a
being,
good example
a
of like
judge.
effectively the
Could
same
we get
thing.
some clarification on what documentation
I'm actually
there is for
surprised
this
the books
process?
require
Because it's not
a
inherently
subpoena.
clear. I think, like looking back on previous decisions that have been made by
I
magistrates,
sent you
if
stage
they were
4, 5,
directed
and
by a
engines.
justice, right? Like, could there be a little bit more
Very good. 4, 5, and
open, not like
engines, right?
open, because it's not like you guys are
Yes,
being
yes.
shady about it. I don't want to imply
Okay.
that, but like a more
Awesome. Thank you very much. I think that's
Really
everything, right? Did I
obvious,
miss anything?
yeah,
4,
maybe
5
yeah,
engines.
transparency, not the word I'm
We
looking
got
for, but obvious
6
like case of this
turbos,
occurring.
tire. Oh, tires.
Like
I
if
need
a
to change
magistrate
tires.
were to do
tires.
it, could
Awesome.
they include it
All
in
right,
their
thank you very much.
decision
I
that this
appreciate
power
it.
is granted to
No
them or
worries. Yeah.
something, so that there's
Right.
an understanding that it's not them acting unilaterally and they do have the authority, right?
Yeah, we can do that, yeah.
Because it
Yeah,
would
we
be,
could do
it would just
similar
be
to how
helpful.
we can do it similar to how we have them do it on the docket now, where when they enter in something that they're not just allowed to do, it says who is giving them permission to do it.
Okay, that's good. Because it just prevents or helps prevent officers from that might not necessarily understand the powers of a magistrate. And I'm not saying anyone is doing this, but if they were to like go rogue or whatever, do whatever they want, like not like stand up, but acknowledge that it's not correct in the moment, right? So as long as that's a standard that's there, I think that'd be very helpful.
Mhm.
Okay, perfect.
Okay. Next one I have here. Section E. Let me see here. Signing and execution. I'd like some more details in legislation around lockdowns. Currently, under Section E8, law enforcement agencies may lock down properties, garages, and assets named in search warrant that is actively being written or pending approval. So I guess my question is, if you look up further under Section E4, law enforcement agencies that received a signed search warrant shall have no more than 2 weeks or 14 days.
Dude, that is
moment
the
a judge or justice
best
from San Andreas Department of Justice
emote
signs a search
ever,
warrant
bro.
to execute said search warrant.
Fuck.
And then
We need to
under
open
that,
more
this does not
boxes.
mean the
We
property
need
remains
to
locked
open
down
more
for 2 weeks. There's no
boxes.
in between here. It has a very vague comment of does not mean it's locked down for 2 weeks. And then at the bottom under 8, it states it can only be locked down technically by this verbiage. It can only be locked down while it's being written and pending approval.
Oh my god,
So
we
once
can
it's
buy
approved,
2,000
there's
of
nothing
them.
in legislation that allows us to keep that property locked.
Yeah, I would actively I'm gonna say something here that's gonna make me look stupid, but it's important anyways. This section was very hastily written, and it was essentially in response to officers that were just locking out a property and had essentially no intention of fulfilling the search warrants anytime soon. And this section was not written with full like the full depth that it actually needed to be to detail this process. I would recommend that you guys redo this timeline so that it actually makes sense from like an executive level or like from a functional level. You know what I mean?
Yeah. I guess sort of I think the idea behind it is once you start writing it, you can lock it down, and then it stays locked down until you execute it. Is the idea?
Yeah.
Absolutely. I'm just wanting I understand the idea and the concept behind it. I just want writing behind it as well, right?
Mhm.
If it's not in writing, it's going to be exploited and used against us in some way, shape, or form. And the fact that it's not in writing, even though it's implied, kind of surprised me that no lawyers picked up on that and tried to go after us in some way, shape, or form, frankly.
Yeah, that's fair.
Yeah, I mean the idea behind this section would hopefully be to not allow us to just like hold someone's property on lockdown forever, but just as long as we need to execute the warrants, basically, right? Like for us to get the units together and do it, because it, sometimes a warrant will get approved in the middle of the night and there's only like 6 cops around, and it's just not really effective to do it then. And we'll need to gather the manpower, right? So we just need to legally be able to extend these lockdowns until it's time to execute it, basically.
That's definitely something we can expand on.
Okay. I wasn't sure if you want to expand on it here or if that's just something you want to note down and next time we meet about this.
We can talk about it now, like, I mean, in terms of like what the needs would be, maybe.
Okay.
Like if there's specifics, like what is the maximum window, what is, like, whatever caveats those are, so that when it is written, those things are done with that in mind.
I mean, I guess a question would be, it says you guys have 2 weeks, but has it ever taken you guys 2 weeks to ever execute a raid?
To my knowledge, the most I've known is maybe 4 days. Maxwell Peters, Viv, what's your point of view?
I think the maximum I've known is about 5 days.
That's already a lot.
Attempted, and then we've had to revisit like a few days later, maybe after the weekend. Yeah, probably 4 or 5 days maximum. We've done them in the past.
It's been months since the last one went that long. Like actually 6+ months. I don't think that's
that received a signed search warrant shall have no more than 2 weeks or 14 days from the moment.
Yeah, I put that
judge
2-week time limit in because the warrant that Dunn had signed had gone on for like 3.5 weeks or something, and so I was really pissed that he hadn't served it yet, and so I put it in there.
What was the situation surrounding that?
I don't remember. It was something surrounding Hydra. There's some circumstances that made him delay, and officers were feeling unsafe, and then I guess they'd been like wiped and they didn't want to go after it again. I don't really remember the specifics. I just remember that Denon was involved and I was not happy that they hadn't served it yet.
Was that the incident that spawned the tunnel retreat team?
I think that was a different one.
Yeah,
I think
that was a
separate
different one.
Yeah,
there's a separate one.
There's a few different incidents that happened, and I frankly don't remember.
I'm kind of trying to put my head around the need here.
I was just explaining why that was put there in the first place.
Mm-hmm.
Realistically, I can't think of a reason why it would more than 7 days would be needed.
Yeah, but I just don't think people should have a guillotine hanging over their head for super long times,
Right.
If it gets approved, we should actually do it, not just sit on it.
There are some circumstances I can imagine coming up that would delay it, especially organization and manpower, things like that, depending on the time it's done.
I'd also imagine the location of wherever's getting raided plays a big factor in that.
Absolutely.
Yeah, like, I mean, if you find like a fucking, apparently there's like crack on the street, which I only just learned about a couple days ago. If you found like a crack den, right, owned by somebody, I imagine you want to lock that down until the conclusion of whatever, right? Is that something you need?
Sugar, by the way.
Oh, so it's not actually crack?
No.
What the fuck?
I mean, there's an infinite amount of if, ands, or buts, right? About situations that can change the outcome. I'm trying to think of any combination of those off the top of my head, or any other law enforcement here, or anybody in general, which would prevent us from raiding a property for more than 7 days.
So,
is there a circumstance anyone can think of?
Yeah, we keep going back to the Hydra block, and they keep gunning everyone down every single time.
I don't necessarily have a problem with the 2 weeks, though. My thing I want to focus on more so is when you enact it, because I presume that's what you're trying to get protected, is like when you lock it down. Like, procedurally, what would be optimal for you guys?
Well, I mean, I'm talking about lockdown, absolute lockdown. I guess I was jumping the gun here, assuming that, I mean, if we're going after a search warrant, the property should be locked down. At that point, we no longer, any probable cause we push forth can even be tampered with at that point, right?
100%.
So it needs to remain locked. I'm assuming you're going to say 14 days is too long. I agree. I don't think 14 days, but I'm trying to
So that's why you want to cut it
explore.
down. So
That's
so
why I want to cut it, or am,
Okay.
am talking
Yeah.
about cutting it down. I don't see.
That's why I was curious, because I wasn't sure. I wasn't sure why we moved to that, but now I understand what you guys are saying.
Right.
why
So
you wanna
I
cut
was
down
more
the
so,
time.
I guess, trying to find a happy medium there. But my ultimate goal is to make sure that we're protected and that we keep the property locked down. In no standard situation should we be taking 7 or 14 days to raid a property. But yeah, my goal is
The
to
app has been
get us protected
updated.
and
Oh
put that in
shit.
legislation that we can lock down a property and keep it locked down until the raid's conducted.
So I don't think 7 days is crazy. And I also feel like, let's say the worst does happen, right?
I'm in a meeting.
A properties gets locked down for 7 days straight, not allowed to get in at all, and they do the raid on the 7th day in the 11th hour, and then it gets done, and the people who own the property feel like they're wronged. I feel like that is a civil suit, and something could be included in the legislation to say that, like, asserting that you guys are making efforts to raid the property and that the raid should be done as soon as it's possible. Obviously more fleshed out so that it's not such loose wording, but I'm just doing it for the sake of brevity here.
I have no
but I would
problem
imagine
with
in that world,
lockdowns
like,
being longer.
if someone feels like their property was locked down for
Like-
too long and like they want some sort of restitution,
But,
they could
like-
go for a civil suit on that. That's my opinion on it. And then, like, that would come to a point where you guys
Because
would
the
go to
thing
court
is,
and
like,
say, well, we tried to raid it like this time, that time, and this time, and these things happened, so that's why it was locked down for so long.
Wait,
or,
has
like-
someone actually so just to set my understanding here, if the PD locks a property down and it takes a week, what leg does anyone have to stand on for a, like, is that something that would even has been entertained in the past?
I think it would depend on why it took a week.
Like,
Yeah,
even if
that's kind
a,
of what I'm getting at.
but the thing is, like, if a property is put on lockdown, be it a day, be it a week, that the duration of the time that is locked down seems irrelevant to whether or not there was a violation. Right?
Right, and that's
Well,
why what I'm
And-
getting at with, like, the civil suit thing. 'Cause
Right.
that could be determined in court if that's the case, where the PD says, well, there's real reasons why we couldn't do it, or maybe there isn't any real reasons and they just admit that there's no real reasons why it didn't happen.
Well, my point
But-
being that, like, the duration, it's a variable, but it would be whether or not, like, that raid warrant was written in bad faith or not, right?
I think the idea behind someone who would be appealing on these grounds, and I have seen these cases posted, I don't remember the outcome, but they do, is that the extra long wait is essentially punitive in nature. It's not because the PD is actually trying to get this evidence out of the house in a reasonable, good faith manner. They're
How
just
is
locking it down
that shouldn't be
to lock it
punitive,
down
though.
and to be spiteful or to punish them extrajudicially, right? I think that's the idea behind those appellants.
Interesting. It's interesting.
And
So,
it
you know,
is
are
it
you
is a valid
saying-
point. Frankly, it is a valid point. You know, the police shouldn't be holding someone's property in lockdown for the 13th day just because they can, right? You know, that's not something that we even want to do, and also not something we should be capable of doing.
Okay. Why don't we
Yeah,
just
that's-
add an approval process to it? Standard 7 days, but can be extended to 14
Extended,
with judicial
yeah.
approval.
That's a good idea.
You know, and we just, we have conversation
It'd
that
be
we need to
just
speak
like
with a
when you
judge
hold
to.
somebody,
Uh,
right? Where it's just like, hey, we have this guy on a investigative hold right now for the 24 hours,
Yeah.
but we want to have 72. And it's like, all right, why do you want it for 72? Well, we need this, that, and the third. Okay, boom.
that
there you
would all go on in private communications via our joint communications, or how would that, where would that be?
It could happen in
so
person, but it could happen
20.
there as well. Just like how
Oh,
when you guys
shit.
put on people on
I put
investigative
the wrong
holds
ones
and
in.
want more than the 24 hours.
Anti-roll is
That's how I see that happening.
5,
Like, it's
and
like, hey,
then
we have this house locked down.
clutch
We're probably gonna need
is
longer than the 7
7.
days because we're on day 6 right now, and we've been having trouble doing this, that, and the third. And it's like, okay, how many days are you asking for? for, and then give an extension based on that.
Would you guys want it like that, or would you guys want us to basically like
Yes.
copy paste the original search warrant and add a section to it to apply for the extra time so that it's in a formal format? Because if they ever did go to appeal, this would, this would be brought up as well, as opposed to internal communications.
Yeah, but I'm so confused. Like, why this
then you can put a
this doesn't
signature
need to
to
be
it, right, as
fucking
well? Like,
legislated.
there'll be an actual
True.
signature.
That's why
that
there's a
they
court case. We
say
don't
that
need.
You agreed to extend.
This is solving
the
a
time that
court
we could
case
conduct the
outside of
lockdown to
court,
be able
in
to
my opinion.
conduct the search.
I mean, at the same time, I maybe it's not a route we need to go down because I've never seen this issue, but I guess closing holes is important to you.
It is good to have
Because-
options.
Yeah, that's true. I see what you're saying, but that also means that there is a
Expires
hole with
38.
the investigative holds as well, because that's how we do investigative holds, either we talk to you in person or we just communicate.
don't-
I
through the
feel
normal-
like as
We
long
don't-
as there's some written communication, it doesn't need to be like a formal document, right?
I mean, so let me ask this:
It
why
would.
can't we provide internal communications if something like that was contested?
Yeah, I think it
which
should.
I think
you
I
would
think
want
stuff
the
in that
defense
right
to
is
be able to
fine
see
to
it.
provide. Yeah,
I don't think
Like-
anyone, a
like if
judge would
they
be opposed
asked-
to that.
yeah. Like I think if they ask, like, "Hey, where's the proof that you're allowed to lock down the house for extra days?" and you could just show them that, like, "Oh, look, Justice Danielson said that
Yeah.
they had to lock down for another 4 days."
It's good for everyone too, because in the event someone raids a property and then fucks off for like 4 months, you know what I mean? Whoever has to defend that in open court can like produce the documents and be like, there it is, boom, that got extended because of XY reason. It's all documented for everyone to see.
Yeah, and then with that being
It's
said, I
true.
think we can make sure that that is documented through that channel as well. So, like, even if we talk to you in person, that
Some casual
you guys
den.
put up the thing and
den
ask for it in
shit.
there, and then we put in the approval in there, so that it is documented, so that no matter how long it is afterwards, like,
Listen,
Nino
I
saying,
love
it
Den.
just
That's
be
the
pulled
only
up right
reason I do it. All right.
It's understandable.
Den-
I don't disagree with that.
Den is like Den is a
Documentation is always good.
I feel like Den is
So then we're agreeing
he's
to
a
allow
test case.
internal documents in this case as proof of us requesting the extension. Are we talking extension here?
Well, I think
talking
that
extension.
they're talking
No.
about creating an external document in addition to
Yeah.
the internal communications.
Yep.
That can be transmitted.
Okay, so we are saying a separate document then. Okay.
Mm-hmm.
Well, no, I was saying just like how, like, we grab a bench trial or anything like that.
Yeah, that's what I was saying as well. So
Oh, okay.
Oh, I'm
Just being able
suggesting
to
it should
provide
be
that.
written. So like today you
Okay.
do a subpoena in as a report, right?
this is subpoena, yeah,
Yeah, so
similar. Yeah.
in the same vein, I think it was the undersheriff that had mentioned it. Is do we take the original subpoena, put it back in there, and get it re-signed? I think it should be something like that. Both for y'all's, like, you have someone in some shift do something, you have record of it, right? That you can just immediately look at. You'll be able to pop it up and be like, oh, someone extended this. But in the same vein, that ensures that all parties, like if those documents need to be produced in a court case, that those documents can be produced with ease. If it's
Yeah.
only internal documents, now all of a sudden, not only are y'all going to have that issue of like, hey, why did this happen? You got to look through like email chains and shit. Or, what if that's not produced? And, it makes everything a lot easier, I think. It's, and what is it? It's probably like 2 sentences, right? Like, it's probably not a lot anyways.
Yeah, I don't disagree with that at all, actually. Because then how I imagine, like, the extension for a lockdown, it would just be like you make a subpoena, title is extension for
Yeah.
lockdown for raid warrant number, and then you articulate inside why you need the extra time and then how much extra time you need.
Yeah. I'm going to throw even a bone out here. Like, once again, I'm going to use that crack den example. If y'all found a crack den, right? Y'all need that ability to extend beyond the standard 7 days regardless, unless we're talking about, you have evidence that cracks being made somewhere and you're unlocking it down. That sounds a little crazy, right? And that avenue would be that same avenue where you're like, hey, we fucking raided this thing. There's active crack in here. We're not going to open that back up to whoever owns it, right? Especially if some of the whatever it is you find cannot be demolished.
So,
Are
so
you
what
following
would
my
the
train of
process for
thought?
something like that be, though? That's not just a standard search warrant, right? Like how would we apply for something like that?
I think there would have to be an
Yeah.
addition to the legislation as a whole to talk about seizing properties.
Well, it was pre-seizure, right? Because the court case hadn't concluded, but you have evidence that the crime can continue to occur, and therefore that area vicinity, whatever, needs to continue to be locked down. While
So
it
you're-
may not be I would imagine it would be the same avenue. However, you're asking effectively for a court order to, maintain a lockdown for an extended period.
Right.
Probably be like an injunction of some sort.
Yeah.
Yeah. I feel like some of these like more nebulous things that are very rarely going to occur do tend to fall under just like blanket judicial powers that are already codified to them. And I don't know if it's necessarily worth carving out these exceptions and whatnot when they could already be performed at request of a judge, because property seizures are not really documents anywhere unless I'm mistaken.
No, they're not.
But they still occur, and they've been held up and lawful in the past. So
Yeah. I think while we're
Also,
doing
reminds
it,
me
we
of
should do
property
it.
Contracts written by the state are fucked.
Sorry, say
Yeah,
again?
You ever looked
was
at a
that?
property
Contracts that you get?
contract, Nino?
those exist.
On
Yeah,
the
whenever you
phone?
buy it says you
Oh,
record
shit.
of transactions for home purchase for the county of Los Santos, but that'll show even if you buy a house in Blaine County. Then it says the seller name is Los Santos State, and then it says that judges can grant foreclosure on properties.
Oh my God, they're all mine.
Technically, they're all ours.
Interesting.
Share that
All
one
right.
more time.
Yeah.
Have you one of these?
You get that?
Holy shit.
It's just one line. You
No,
share it.
scroll down.
It
Yeah,
doesn't
you-
even
yeah,
see.
You gotta scroll down.
Oh.
Yeah, there's the whole thing down here.
Yeah, state shall not file for foreclosure until either.
Huh.
But yeah, like these are fucked.
Oh my God. Oh,
2 weeks has
that's
passed since last payment. Buyer is confirmed no
Wait,
longer to
2
reside
weeks?
within or grant by a judge.
I don't even
granted
know
by
this
a
is a
judge
thing.
for foreclosure.
Yeah, I only discovered it like last week.
Hang on. So if they don't pay for 2 weeks, it can be foreclosed on.
Oh my god.
Yeah.
The state shall not fail,
Which-
so the state
All
could.
right.
Which who that is? I guess Sama is the closest to the state that we get.
well. It says
I mean, this
shall not
state is
file.
like the governor and like those guys.
Yeah. It says the state shall not file. That doesn't mean they
Until.
couldn't file.
Either.
Until.
Yeah.
Yeah, until
It's
either
not
any of these
cannot,
happen.
It's not cannot. It's
But
shall
that
not.
doesn't that doesn't necessitate it will. But this is wow, that's gonna draw a lot of fucking questions, especially with the some of the shit
We've
that's
been
been
selling all the
happening.
properties.
Oh my
And
God.
the last one, granted by a judge for foreclosure. Like, can we just buy this contract? Just say that someone's house is foreclosed on? Like,
Ah,
That's a good question.
The other is like, who has the other side of this? If the, you know what I mean?
it says
Like,
Los Santos State, which is, I don't know, that might be your goal, but
That's the previous state, which is null and void, though. Remember, there was the whole thing with Soze and being like, Los Santos State's not a thing. It's actually the state of San Andreas. And we have the court case, and then we made the new constitution and all that.
it was a good storyline. I liked that one a lot.
So, yeah, I don't know. This contract might need to be updated or something.
Also talks about HOA dues, which PTSD.
Oh my god. I think we talked about that for what, like 30 minutes, I think.
Yeah.
It's about
Well,
40
I
minutes.
think that this might actually be a good indication that maybe the county should start writing some legislation surrounding property ownership and the, details surrounding it.
Skip.
Right? If it's such a gray area, maybe the county should clear up those gray areas for their residents. Something to consider.
Yeah, true. Yeah, I don't think that's a bad. I think there's some in Blaine County. I think for like giving like Mount Chiliad away or some shit. But
You can make
yeah.
those raffles fly through the roof.
Oh my fucking god! The touchy thing about this is like then you get into the whole like whether or not we can give away property. Does the state own it? Does the county own it? As there was one point in time where I was told very in explicit words that we cannot give away anything or sell anything that was not on the app, and then all of a sudden, properties started popping up and undisclosedly for $0.
Interesting.
Yeah. So,
yeah, going back to the legislation and property seizures, that can definitely be added in. Like, should a property be determined, in a court case, it could be seized as part of the sentencing.
Okay.
yeah. What did we conclude on that in regards to, we just said injunction, we don't need to use the same. We are in agreement that if there is an extension that is required for a lockdown, that it would go through the same way that you would write a subpoena, through that same documentation chain, right, with the report and the sign off
process.
and whatever. Yep. What about if it's other things along those lines, right? If that opportunity does present itself, I would argue that it should be in that same fashion. And that should be noted in this update. So
you're talking
that
what,
if
exactly,
you're
in detail?
asking to hold something down, but then again, I'm not like hard pressed on it because as someone else, I don't know who said it, that you could just file the injunction on the docket. My only concern with that would be that if you're doing some big investigation, let's say even within a 30-day statute of limitation, do you want to post all that to the docket right away, right?
Yeah, I guess when I said the injunction, that's to like keep it locked down after the raid if the intent is to try and seize the property.
Oh, yeah. But they'd have to post their evidence then, right?
Well, yeah, that's just, we'd assume, the people, a raid happens, they found, I don't know, 14 weapon benches and 25
Yeah.
AKs and materials and whatever. So they want to seize all that and then seize the property. So they would post the weapons manufacturing case and go from there and put the injunction on, like,
I don't think they have to put
no
that
one should
all in
have
there.
access to this property.
I don't know why I'm arguing for cops on this one.
Matt, that all's already in place. Is under the judicial. What's the word for it, user?
Yeah, this process already exists there. So
Yeah, so it doesn't exactly
what
need
word
to
are you
be
looking
in
judicial powers is already under the judicial powers.
Yeah,
judicial powers,
so
sure. Yeah.
preliminary or permanent injunctions. Yeah.
Yeah, I mean this is something the judges can already do it at our request. Their discretion, our request. So
I guess going to what we agreed on was 7 days standard, and then it could be extended up to 14 with a request through the same process as filing that search warrant.
Yeah.
But those 7 days is a hard lockdown. We all concur on that?
yes, I would think we all agree. Yeah.
I mean, I think what you're looking to extend on is the lockdown aspect of it, right?
No. I mean, this first 7 days is what I'm saying.
Like the first 7 days, it's on lockdown until the raid is conducted.
It's not
and
like
complete.
how it is now, where you can do it in those 7 days. It's the property is hard locked 7 days until the raid is done. and then you can get an extension to the property being completely locked down.
I mean, in my mind, the moment that you have a search warrant, that you're certain, going to be putting forth a search warrant, that property can't be unlocked. We have to secure it. At that point, you have a variable involved, which can throw everything out the window. But yeah, as long as you're planning on serving that search warrant, it should be on lockdown. They kind of go hand in hand.
I think we're on agreement on that for sure.
So search warrants are valid for 7 days by default, which means inherently the lockdown should go with that. That probably should be black and white and in writing.
Yeah, that's what I was trying to get clarification on, making sure that we're switching it from just that you can do it in the time period to the property is locked for the time period.
Both of those would be good, yeah.
Oh, so these problems aren't even an issue yet? I mean, technically none of it is, but I don't think PD knows what they need to do to make sure that happens.
Anything else that you guys have?
Is the thing.
Yeah, we have a few things. Do you want to go, Turner, or?
Well, this one's probably pretty easy and quick to touch on. Section F, 3B. The last two words on there are judicial discretion. I'm curious what that. How is judicial discretion applied here?
So I was the one that wrote this contestant of a search warrant, but the intent behind it was for, if it seems they were acting in good faith.
Let me get the engines in.
It was a good faith exception.
Oh, we got a new one,
basically. Because it was initially wrote as, if it's overturned, then all the evidence gets thrown out.
Okay, hold on. I'll put that in a sec. 1.6 VVT.
We've now came to a sort of position on search warrant contests where we, if it's just, arguing the is it 49% and 51%? If it's that close.
Wait, we got two.
It's sort of not something I want to entertain. So we only really want to entertain the egregious issues, and so this line is kind of redundant at this point because in the search warrant contest that we'll entertain, it would need to be egregious and it would more than likely get things overturned, including the evidence.
Or 3 liter.
So at first
so
the line
just
was
to
like,
clarify what you were saying, so this essentially is already included in the search warrant appeal panel part, and this is redundant, basically. Did I hear that correct?
Yeah. So when we're rewriting this, the idea of the poisonous tree, that sort of idea in itself is going to be explained out. I think that's something Grayson's going to take care of. Good faith protections for if a warrant is executed in good faith and then it turns out either something was wrong or whatever, then that good faith exception still applies.
When I spoke to Grayson, it was when we talked about it, and
3.8
Nino a bit about it. I expressed to Nino,
okay,
and me and Grayson are on the same page of
the JCs.
When warrants are being overturned, it shouldn't be because officer so and so used the wrong word. It should just be like,
there's a SP
if there's a
QT.
fundamental issue, that is something that is like a serious issue, not just like what Falconer said. Is it 49? Is it 51? Like not the small issue. Just if there is not PC and it was signed improperly.
Where'd the ST go?
So his idea for it is kind of changing the standard in which they can even be contested to be for like serious reasons and not just I'm gonna re-roll and see if a different judge disagrees with the one.
Right. We had STs
that brings
last
up something
time.
else that Turner had actually mentioned. Is we also wanted to talk about if you guys are going to be putting that into legislation as well, the standard that you just were discussing with us, or how is that going to be communicated and understood out to people?
What do you mean?
So specifically in the DOJ expectations document, it kind of outlines what you just explained to us, that the probable cause of a search warrant isn't necessarily enough to attack it on. Is that going to be like expounded upon or explained in the search and seizure legislation?
Yes.
I didn't add this last
Okay.
time for some reason. Yep.
Specific wording and how we're going to
Or-
word it, that's not settled on, but that general idea is going to be in there, yes.
Okay. So essentially, a lot of the stuff that we just asked you guys for, you're already in the process of rewriting and doing anyway.
Mhm.
Okay. All right. That makes sense to me.
I
That's
think
good to
that's
hear.
most of the points I have that I want to bring up specifically,
Okay.
noted at least.
I had a
Turbo
couple.
i6.
If you want me to start.
Yep.
Absolutely.
All right. So the next thing I wanted to get at was on the topic of search warrant appeals. It was
Turbo
kind of
i6.
discussed, and I
There
thought
we
that this
go.
might be important to think about, that the judge that signs a search warrant carries a level of liability in the warrant itself, right? If the PD is getting sued for a warrant being bad, the judge that signed it should also be a defendant or in the hot seat for this search warrant. And I was curious what you guys thought about that. Like, what's your thoughts on that being the standard?
Turbo i6.
I think it's certainly, yeah, it can be the case. It depends on why a search warrant may have been overturned. If the judge just didn't do the due
One
diligence, let's say,
JC.
the warrant had the wrong address listed and they never checked the person's profile to see if they actually own the place.
5v8.
Yeah, that's on the judge.
Yeah.
But like if like an officer deliberately hides something from the PD, and then it's like, well, how is the judge expected to know that that's a lie for some reason? Something like that. I wouldn't want to hold the judge liable or anyone liable in that case.
Except for the person that was trying to obscure evidence,
Mhm.
obviously. Yeah. Well, that makes sense. I guess the main point that I'm bringing up here is in the legislation, basically, it says that once a warrant is signed, it's lawful, and obviously we can contest them and whatnot. But there have been cases where,
3-6.
well, not I wouldn't want to say cases where, but there's always the potential for cases where the PD could push a bad warrant, and conversely, a judge could then sign that bad warrant for bad reasons. And I don't think that the liability should
This is
rest
a
solely on the
court
people that push the bad
that
warrant in that case, right?
doesn't-
So I just want to
this-
understand if the DOJ is in
This doesn't
agreement
need
that if a judge were to
legislation.
sign a bad warrant for bad reasons, then they would also share that liability in
Yeah.
kinds.
Yeah, we can put in a hallow clause.
A what clause? Sorry.
Hallow.
Oh, the hallow clause. Oh, that's
Yeah.
perfect. I love that name. That's actually that's a great name to call it.
It's just signing a warrant and then going on the raid and lying on the person's couch.
Yeah, that was a disaster. Okay,
Yeah.
perfect. I'm actually quite pleased with that. I think that's pretty much everything I really wanted on regards to that. You guys have anything to add before I moved on?
Nope. That's great for me.
Oh, that's good.
Okay.
It's huge.
Let me see my notes. I actually think we brought up some of the stuff in like the side conversations. So yeah, that's pretty much everything I have in my notes too.
Something that we're going to expand upon that I think it was going to come from a case law, and then the case took 6 months because of shiesty. Exigent circumstances, those are actually going to be, it's going to be like, here's what are exigent
37.
circumstances.
Okay, that's good.
Hang on. One more time.
The idea of exigent circumstances, like reasons you could go in a property without
Yep.
a warrant.
Absolutely.
Yeah, those will be properly outlined. I think they're
Okay.
written up in a case law that was going to happen, and then, like I said, the case took 6 months.
I see. Putting exigent circumstances into
40.
legislation is what you're saying.
Yeah,
Wait.
like life
God
and danger
damn it!
exceptions, hot pursuit, stuff like that.
I have to do it
Okay.
again. Fuck.
Okay. Was there anything anybody else wanted to bring up in terms of search and seizure legislation?
Not for me.
No, not for me.
Yeah, I'm good.
Maxwell? All right. All right. Well, I think if that was the scope of our meeting. If there's anything
Oh, it
else
is
y'all want to bring up
36.
today,
Wait, it's saying it's 36.
Uh,
Did I?
we're open to it. If not, then I think we're all good.
One,
Yeah, I don't
two,
think it's easy for
three,
us either.
4,
So,
5,
you got anything?
6, 7, 8, 9, 10, 11, 12, 13,
Harry, Nino.
15,
Probably no. So,
23,
No.
4, 5, 6,
uh,
28, 29,
Harry and Nino, could I grab you
30,
guys' ears after this?
35.
Actually,
3.
Well,
Um,
thank
Yep.
you everybody for your time. Really do appreciate it.
Yep, no
Yep.
problem.
yeah,
5,
thank you
6,
again, Your Honor. We
7,
really do appreciate it. I know
8,
it's
9,
kind of
10,
boring, but it's
11,
very important stuff too.
12,
So,
13, 14, 15, 16,
It is our
17,
jobs.
18, 19,
100%.
20, 21, 22,
Why we're
23,
here.
24, 25, 26, 27,
All right.
28, 29,
Y'all have
30,
yourselves a
31,
wonderful day, all right?
32,
You
You
too.
do. You guys
Hey,
stay
Chief,
safe.
can you grab me real quick?
all right.
Sure can.
It's not
So
appropriate,
I
man.
just had something really quick I wanted to mention.
God
to you.
damn it! Okay, it is 40. All right.
Nino, could I have a chat with you really quick?
Yeah,
after this
sorry,
too?
I was counting things.
Okay, actually, I guess it's just really quick. Something to mention to both of you.
Yeah.
So for Perry, in your pharmaceutical business, you mentioned charges, but
Yes.
there's no actual charges created. Are you gonna create a recommended charge to push for that?
BV
No, I didn't see it in the
1.6
legislation. If you could just go
liter.
through really
Okay,
quick and-
almost.
and double check that
Wait.
so that we know what we're to be
Yeah.
pushing.
2, 5,
Let
6,
me
7,
look.
8, 9,
Okay.
10, 11, 12,
And then
13,
Nino,
14,
the main
15,
thing I wanted to
16,
bring up with
17,
you is
18,
just
19,
some clarification
21,
on
22,
the
23,
mass shooting
24,
charge that you were doing.
25, 26,
My
27,
understanding is it's an
28,
umbrella charge, correct?
29, 30,
And it's
31,
to
32, 33.
supplant previous attempted murders if it goes over that number. Is that right?
So that one was written by the police department.
Okay.
We massaged it a little bit. Let me actually pop this open real quick. Where is it? Give me 1 second. Okay, so sorry, what was the question again?
So basically, this mass mayhem charge, it's not
Mhm.
entirely clear to me on my reading of this if this is an umbrella charge or an enhancement charge. I know that the idea is for it to be an umbrella charge, but I don't know if that is the impression that I get when I read it.
It is umbrella, and what we're going to see. So so similar to the search and seizure legislation, older legislation is either getting like combined into like a bigger document, and it's also being reformatted in such a way that if there are sections, articles, whatever, they can be updated with a bill. One of the next steps that is going to be happening is the clarity for every charge that is in the penal code as to whether it is an umbrella or not, or if it's an enhancement. So this is meant to be a umbrella, but anything that is an enhancement will be explicitly as such.
Got it. So you're
Yep.
talking like in the penal code, it will like show as like a separate thing, right? Is that what you mean?
Yeah, it's probably going to be on both. So anything that is an enhancement should be very clear it's an enhancement. Because I know
Okay.
there's been a lot of concerns over a good example is the EMS stuff that's been happening lately. So for example, if somebody were to tow an ambulance with people inside of it that were retreating medical, it could be felony obstruction, but it could be a series of other things on top of it, like attempt, like manslaughter, or what is the one, like reckless endangerment and all those other things. So
Okay.
yep,
That makes sense.
Yep.
The other thing I wanted to mention on it is there's a section here that also mentions that there will be an enhancement made in the case of a death in a mass shooting, but it doesn't really expand on what that is. So with what you just explained to me, does that mean that there's an enhancement to come in another bill, essentially, that will be related to this? Or
no, it can be enhanced in the sense that, let's say, so it's kind of broad, because ultimately it becomes like how the court ends up ruling on this. So I'm gonna provide an example. Like, for example, there's, I don't know, a bank truck, and let's say 30 law enforcement officers go down. 5 of those officers end up in ICU. That individual or individuals can be hit with attempted mass murder of a government employee. However, similar to the delayed death exception, if those individuals end up dying, in addition to that, it could be murder.
I see. Okay.
Yeah.
So the enhancement is essentially just authorizing officers to push a murder charge on top of this, right? That's just essentially like a allowance in the case of that.
Exactly. Yep.
Okay, that makes sense then.
Yeah.
I understand that.
And we did consider putting other things on there too, but we haven't yet. I mean, until someone kind of pushes us in that direction. But let's say in the same sort of circumstance, some number or a singular or multiple individuals end up getting, I don't know, something else theoretically takes place. You could then enhance it as well. But we left it to murder for just now. Like someone gets like disabled or something, you know, like their fucking leg gets blown off. You know,
that makes sense. Okay, yeah, that pretty much clears up all the worries that I had about it. Thank you.
Yep, absolutely. But
I have a question, Nino.
Mm-hmm.
It's just an update, really. I don't know if LSPD received an update about it, but the criminal code and the firearms, there's been a little bit of an issue there.
Yep, that has been submitted. You're talking about.
Okay, it's been submitted. Okay,
yeah, it's been fixed.
Yeah.
Yeah, there's no tampered firearm in there, and there's no.
Yep.
Yeah. Okay. So, is that getting updated soon? Because I'm still seeing the old one.
Soon is yes. I think it's been 3 days, so that should have been approved. It takes a little bit of time for it to migrate its way into the penal code, and I think that's also why some of the scheduled related stuff hasn't made its in just yet. On that subject, though, there are other charges that we uncovered along the way. For example, you cannot charge anyone. There's a lot of missing stuff. I'll just leave it at that. Not so as not to cause you guys to spiral. But
okay.
Yep. You may also, we haven't decided yet, contemplated in this area, adding more judicial discretion charges like catch and releases, because we do believe that there are some things that just don't make any sense. So like extortion, for example, right? Right now it's like $500, and arguably you could go to civil for that, but it doesn't make any sense because if you extorted someone for $10 million, then what, right? And this is stemming off those recent terrorism cases. Like there may be.
So I guess I'm wondering. So you're saying catch and release charges? What do you mean by catch and release? You're saying don't push the extortion charge, or what do you?
Well, today you would operate as you would, right? But like, so like there's the, you know, the stuff with Yuri, right? Some of those things, like let's say he successfully got off with $5 million, right? Then what, right? Is he $500 for extortion makes sense? Is there, if the extortion exceeds a certain amount, should it be catch and release? And I think the argument thus far is, yes, there should be a separate charge that once you go over a certain amount, that would be catch and release. In other words, if you took it to the docket, it would be judicial discretion as to what the time and fine is based on, you know, how
would that
bad.
operate? Would that be, you know, okay, this exceeds the threshold. We're going to cut you loose from MRPD with the understanding that this is going to be posted to the docket and you need to appear.
It would be like drug trafficking.
Okay, so it'd be like a hag charge.
Correct. Yes.
Okay. Would they be out on bail?
These are fantastic. These are fantastic questions, but like I said, this is kind of consider what I'm saying is more like a preview of some things that have been brought up in discussion. So I don't want to give like a firm answer since it's not just my opinion, and we haven't really
fair enough
gotten that far yet. So
that makes sense to me.
Yeah.
Good deal.
All right. Cool.
To be honest with you, these are all kind of much needed changes that should have happened years and years ago. So it's good that we're finally getting around to them.
Yeah, it's yeah, some of this stuff is kind of cooked. Like we've got the serial killer one that's probably going to get updated as well.
Some of these charges were written and put in place when I was a cadet 8 years ago.
Yeah.
And we're even older before then, so yeah.
All right, cool. All right.
Oh, just for my pet peeve, could you guys change the attempted mass murder of a government employee to like be case sensitive or not all caps, just so like it's in the penal code properly? Because in the charges section, it's really stands out. Doesn't look good. That's just because it's a work in progress. I don't know. Just
let me take a look real quick.
yeah, if you look at the actual charge in the section, it's like all caps. And everything else like is.
Oh, you're talking about where it's the 3-1, where it's attempted mass murder of a government employee, all caps.
And I'm talking the actual MDT in our charges section. Yeah, it's all caps.
Yeah,
Everything else
Angel,
is.
that was my fault. I just copied it straight from the docket.
Oh, okay. All right.
I don't even see it
Oh.
under our charge list.
You don't see it?
Nope.
Oh, it is in there.
Well, I see it.
No,
Maybe-
it's not on mine. That's
No, it's
interesting.
not
It
on
might be.
mine,
Falconer, did you just add it? Is that why?
I am.
Case
literally
sensitive. No,
typing
you
the
got to
things
type
in
it
right
in
now.
capital.
Yeah, it'll take a second for you.
That's why.
Yeah. It might take a
Oh
second.
wait,
for
no,
MDT
it's
to
pulling up both
populate
ways
it.
for me. Actually,
No, it's not pulling up for me.
It's because
That's okay.
you have to
fresh.
restart your
Fixing
MDT.
it.
Faulkner
Yeah,
is
it's fresh.
actively
Yeah,
adding
they're
it.
fixing it. Doesn't
Oh.
matter. So.
Yep.
All right. Well.
Oh, that is.
Yep.
Interesting.
Okay, it should be there now.
Thanks, Falconer.
Oh my
Appreciate
God!
it.
It's $0 in 0 months. Holy shit!
I'll refer you to
Time to go shoot some
legislation
cops?
where it states it's going to be
Yeah, I
300
can
months.
see
to
that it's right next to
$50,000
assault and
fine.
battery and act
Mm.
of torture.
Thanks, Falconer.
Okay.
Cool. Well,
Oh, 300 months. Okay.
And this is
Cool.
purely to cover the attempted murder charges. So 12 plus confirmed. This gets pressed. So we need to get
Yeah.
an announcement out there on this one.
That's
Yeah.
live as of now, right? Yeah.
Yep, it's live.
Okay.
Yeah.
Wild. We need that charge. Honestly.
I mean, it's actually how it used to be.
Yeah.
The number's the same actually too.
Yeah, but the cap is still going to be 360. Yeah. So
Total
with
cap
the
is 360,
additional.
Yep,
Yeah,
Mhm.
so like possession charges would probably bring it up to around that, right?
100%
Mm.
would. Yeah.
Yeah.
Yep.
All right.
Cool. This has been very productive, honestly.
Yep.
Yep.
All right.
We need to do these
Uh,
more.
She asked you if that pushed it. There should be one soon. Like it should have been scheduled a while ago, but there's going to be one I think every 2 weeks in order to address any concerns from law enforcement. So that way there's kind of like a unified front as to what is desirable and whatnot. So okay.
Absolutely.
Okay. All right. Cool. All right.
Okay.
Okay.
Thank you very
Nothing else we
much.
need to address here. We're all
Nope.
good.
Not from my.
Good deal.
All right.
That's it on
Thanks,
there.
All
guys.
right. Yep.
Yeah,
You
thank
take
you,
care.
everyone.
Anytime.
Thank you.
Oh yeah, Perry. I meant to mention this to you, but I think
Yes.
the schedule stuff, I think you should add that to the legislation itself.
It's going in the legislation. Don't
Oh,
worry.
it is? Oh, beautiful.
Yeah, I'm reworking
Yeah.
dosage.
Oh, hell yeah. All right.
And I'm just about to go tell Angel what to charge somebody with because there was a charge that I thought was still there, but it's not there anymore. So I now have to quickly go tell her. Yeah. So I have to quickly go run and tell her about that one.
Okay. So the
I fix
legislation, the dosage is going to be updated. So it's going to be like
It's-
schedule 1, blah, schedule 2.
Schedule 1, blah, then basically what it is, why it's that way.
I
type of
love
thing.
that. Just because that way, like,
Yeah.
it's all there. And is it going to list out, like, enumerate over every drug?
It should do. I'm trying to remember what I
Okay.
wrote for it because I literally wrote it like a couple days ago.
Okay. That
That
makes sense.
But no, yeah, it should be a lot simpler and a lot easier to install in one place.
Hell yeah.
It's gonna be super long again, so but it's fine. It has everything.
Okay.
Though.
Easy.
All right.
All right.
I need to go chase Angel.
a cop fucking thing, I might be pissed.
Hey, what's up? Are you guys busy? I wanted to bring something up.
No, what's up?
So I had a bit of a, call it an epiphany. I finally had a chance to look at the accessory legislation. I like it. However, I want to make an argument for different percentages. I was going to put it in the email chain, and then I'm like, emails are dog shit, because then we can't go back and forth. So here's what I'm thinking. I would like to advocate that it is 70% and 30%. 70% for accomplice, 30% for accessory. Now, obviously these are numerical percentages, right? So like, but here's kind of why I'm thinking 70 and 30. When someone does something, whatever that crime is, obviously they get 100%, right? That's what the charge is. And then when I sort of think of like an accomplice, 70, like 80% just feels like a little too close to the primary charge. Now, actually, let me first actually establish like a better premise. I think that if there are 4 people inside of a bank doing a bank job, they're all robbing it, right?
Yeah, they're all the primary.
They're all the primary. And then an accomplice is somebody that is like the driver, right? Like right outside. If that driver did not go in the bank, you could make an argument one way or another for that. And I think that is a good one for court, but they're effectively that accomplice. In fact, if somebody does like a pickup, like away from the bank, once again, I think that's an accomplice. The mitigating circumstance is if they make the argument that, hey, I got a phone call to just pick me up. Now you're an accessory. And I think that accessory should be 30% as kind of a consequence of that. Well, not as a consequence of that example, but rather like if you don't really know what the fuck is going on or whatever, and you truly are an accessory, and the PD are pushing or whatever, the prosecution is pushing that point, 30% seems to be a lot more reasonable than 60. So I'm advocating 30, 70, 100. And I think with those weights, that primary charge has more weight behind it, like in terms of like, you know what I mean? Like that the primary actors are getting more weight pushed towards it. Is that kind of making sense? Like the like temperatures, like I'm thinking temperatures, you know what I mean? I suppose the issue we run into is when the police are unsure of when someone is an accomplice, a primary, or an accessory. And like I think that's a skill issue. Yeah.
I agree.
Yeah. And I think, but with that said, I think similar to this meeting, right? What came out, first off, it was a productive meeting, right? But I think what they're needing is more guidance when knowing what a primary, accomplice, and accessory is. And I think the beauty of that's going to come out with the definition document we're going to be cooking up. Because not only is it going to be legislated more, which is unfortunate, maybe it's a good thing that it's happening, is in that like definitions document, accessory, accomplice are going to be a lot more expanded out. So that should hopefully fill that gap. What are your thoughts?
I think when you first said it, 30 seemed a bit low. But I suppose I'd need to like look at what the numbers would work out to be.
Yeah.
Like what would accomplice to robbery work out to be at 30%?
No. Accomplice would be 70%.
Oh, no,
accessory would be 30%. I don't even know why. Is accessory being pushed a lot?
No.
Really?
Okay, so
it mainly gets used for cops to get VAFs on calls. That's what they push. They say, this person this person came in as a pickup. They were an accessory to the robbery of a high security institution.
So to ensure they get it?
Yeah, because if they just do felony obstruction, it's like, well, that's not a violent felony.
Oh my
So they do accessory to the
God,
violent felony.
that makes me want to shoot up the police department. I'm gonna be honest, brother. So oh my God, man, like. You know what? You know what just hurts me internally?
And we keep telling them, you know,
that is literally bad faith. Like,
yeah, it's like we keep telling them, you know, it needs to be used in a violent like articulate how, like, it doesn't matter what the person was charged with. Was the car used in a violent felony? That's what we're looking for.
Oh my God, bro. That just like hurts my inside. You know, cops here are not that much different than cops like in America, you know? It's just, it's like, so, you know, they're doing a good job, I guess. Oh my God.
I know we don't use body cams. You imagine the amount of cops here that would forget to turn on the body cam?
Oh my God. I would kill for like something like that, you know? If there was like a special unit that had more privilege, but they had to have body cams. Oh my God. I could just
don't. Fun to just watch it back.
Oh my God.
If we could put that on a projector, that would be great. So did we unlock something for you with these property contracts being so fucked?
The immediate thing that came to my mind was, does that mean Los Santos County owns the ones? I think we should just we just consider they're invalid. Fundamentally, they're unreconcilable, right? There's it's probably just some shit that was slapped in a long time ago, and
yeah, for sure.
Oh man,
like, even on mine, it puts it says signature of by Murray Falconer, and then it says date, and it also says Murray Falconer. It's like doesn't even do an actual date. It just
a thought that got put into my mind when we talked about that. I just imagine putting in getting state legislation so like the mayors could just be like, hey, this person doesn't live here, and then it gets put up on the docket, and then the person who last paid bills, I guess, would get tagged as well, and then they would have to prove that they're actually around and in there, and if they don't respond, and they get their house seized.
Oh my God. Well, it draws. Yeah, here's the thing, right? I think we are legitimately fixing something that's probably been broken for God knows how long. And I think in doing so, we're probably unraveling things that haven't been touched. And I like the idea for clarity before the problem happens, right? That's not to say we close the gap so there's no court, but like areas that are just like, right? Like I like the idea of us having thought about it, you know? So I don't know. More work for us. We can further what's a word called? Job security.
True.
Yeah.
Oh man. Okay.
Reformat posted right now.
The way they've worded this announcement makes it sound like this charge doesn't exist anymore. They've titled the announcement "New Charge Dropped," so that makes it sound like it's not there anymore.
Which one?
The PD did an announcement that said they've titled it "New Charge Dropped," which I know what they mean. You know, a new charge just dropped. But it also kind of reads like this charge went away.
Yeah, the new Drake just dropped. New charge. Oh my God.
I know so many cops would be disappointed with this one. Oh no.
Well, I opened 2,000 more car boxes today and 0 yotes. We have 1 in 4,000. Yeah.
God, that's awful.
That's some terrible odds.
Yeah, we think it's probably they're more common in the engine. There's like an engine box or some shit, and that's probably in there. But
that's just annoying to have to buy a fucking engine box, though.
Yeah, we're gonna. I'm looking to crack. Those are next. So we've opened 4,000. I think I'm gonna do 2,000 engine pods to figure out what's going on with that. there's a lot of things I've learned from this exercise, and the biggest is how unregulated and how fucked the market's been. Because some of these things are like cooked.
Bad. It was so bad.
Yeah. All right. Let me see. All right. Well, I'm gonna get out of here. Oh yeah, we're gonna be putting a bill in. We're gonna be looking through like the charges that were removed a while back, and we're gonna be reviewing them to see if it makes sense to remove them, and then, you know, do that all again. That exercise actually may have already been done. I don't remember. No, maybe not.
Yeah, I think there's some charges that, you know, criminal transaction of a class 2 and a criminal transaction of a class 3. It's like, when I first went through it, I was like, why don't these exist?
Well, it's
like, if we've got the criminal transaction of a class 1, then why not a class 2, you know?
I feel like my best explanation would be that charges were meant to come as things were uncovered, but transparently, and I'm just going to say this because I don't give a fuck, is that PD's just in a very bad spot. It's in a better spot than it was before, but they're too many of these guys are fucking ping chasers, and those sort of thought processes just don't cross their mind. I'm just going to give you the tea. You know how y'all wrote all that shit up with the search and seizure, right? Because they're like, oh my God, standard. These fucking pussies were literally like saying, we need a TLDR in the meeting today. And I wanted to fucking just open fire. Like, how do you in one breath cry about this shit? Yeah, brother. Like, not the restructure, the document that you published out?
Oh, right, yeah.
The DOJ expectations of court. They're fucking crying about it. I'm like, bro, how are you going to sit here crying about this shit? And then you have the audacity to be like, oh my God, the word of the wall of text and the this and that. And I'm like outside of that echo chamber, y'all sound incompetent as fuck right now to me. Like, but I didn't open my mouth because, you know.
Tom asked me to write this, and like, so I think Grace announced it at MLPD and I announced it at the BCSO, and I said at the BCSO one, don't just go sit and read this. Read this if you need to go to any of these court things, and then you'll know the expectations. You don't need to read it all right now. Read it when you need to.
Yeah, but why wouldn't you read it anyways? You know what I'm saying?
No, I know, but I just know that if I said it in a way of like, you need to read all this, then people would just skim it and say, yeah, I've read it, yeah.
Lord have mercy. Oh, man.
Doing the math on what you proposed for the percentages isn't actually... It's not that bad.
Yeah.
You have an example?
Attempted murder of a government employee is 30 months, 5,000 for primary, for accomplice 21 months, 3,500, and then accessory 9 months, 1,500.
Oh, it updated. Oh, you forgot something with the attempted murder. It needs the reference, by the way.
Which part?
The mass murder references the legislation or the bill.
Yeah, I think that's a part of it. Yeah.
Yeah, I'll done right now. Okay. Done.
I think in future too, the bills, the format I'm gonna attempted. Oh yeah, implementation. I'm gonna section that better so because it's hard to read under implementation. Instead of just like 3.2 should be like 3.1 should be titled legislative changes, right? And then 3.2 should be like penal code changes, so it stands out a bit more.
Yeah.
All right. Okay. Anything else we want to talk about while I'm here?
Not that I can think of.
You know, off the top of my head, I did some footnotes of like the stuff that we talked about for search and seizure, talking about including seizing properties for information for that, adding exigent circumstances, talking about the line change and for the digital contents of the phone, talking about redoing the time of the lockdowns, then the hard lockdown of the property for 7 days, and then an extension with judicial permission.
Yep.
And then the rework of Section F with the contest of the warrant, and then adding the hollow clause.
Oh, you remember?
I don't think it should be called the hollow clause because
No, that was just a meme.
Well, just so we
thank
know
God.
what-
Okay,
yeah, what to
because
add.
that shit was happening well before that. Like,
No,
you know, and
remember I told you Princess said that, you know, over 4 weeks the 16 million had been spent by the DOJ.
oh yeah,
Yeah, it hadn't been.
oh 100. How much of it was?
11.3.
Even 11.3. Where did it go?
A lot of it goes into the cost of sentence lengths.
Oh,
But, you know, like,
right.
You know, the upkeep of people staying in jail.
Yes. Okay.
And
that should
yeah.
be coming out of the state, but it's not for obvious reasons. Which hopefully that gets.
When she quoted me the numbers, she said
Wait,
like
that means they're
14.9.
bankrupt. They got 6 mil left.
Yes.
Something like that, yeah. When she quoted me the number, she said 14.9, but she was including the revenue that BCSO earned from fines as like a cost and not revenue. And I had to point that out. I don't know if she was just trying to get away with it or if she just
What do you
genuinely
think?
missed it.
What do you fucking think, brother?
50-50, honestly.
Oh my God. Hey, on the bright side, I've seen the spending slow down, so
Because they're running out of money.
Yeah. Oh my God. I don't
I had 3 different people that don't know me and I don't know them come up to me and tell me, like, ask how much was in the Blaine County account because they got offered like 8 mil for like their properties up there.
Yeah.
I'm talking like a house or like
my God,
a commercial space. It's just like
I'm dying inside.
Yeah. Yep. All right. I'm gonna get back out there. Appreciate you guys.
Yeah.
Oh, what are we? Wait, what are we agreeing with on the in the 70/30? Are we gonna let you guys cook on it and maybe we talk about it on Monday?
There
Yeah, we'll bring it up on Monday. Yeah.
Okay.
I need
Easy.
to look at, but like, based on going by 30 months scaling it, it works.
Everything says
The
$0 right now.
Huh?
Oh, never mind. Okay, fixed. It must have been a weird MDT bug.
Yeah.
I was like, are you looking at hack charges?
No. It probably had a loading issue. I clicked off and back and it's good. Sorry, what you were saying?
Scared me. The awkward times are the ones that are going to be a little weird to balance out, but probably can be done.
Awkward as in like indivisible type shit?
I think that's what he means.
Yeah, we can figure it out over the weekend.
Yeah,
It's just
yeah.
Monday.
Yeah, just minor edits.
Yeah, and I think that in conjunction with adding clarity to what is a primary versus an accomplice, I think should resolve that. In regards to
100%.
VAPs, we may actually, I'm actually advocating, right? So I'm going to give you a TLDR. These fucking cops have spent the last 6 fucking months, VAP this, VAP that, trying to get legislation forward, and even the latest iteration of it is like, eh. Now, I will say, when I say cops, it's like literally 3 people that were given the job, and they still can't do it. I eventually am like, fuck this. I want to throw the entire thing out, and I want to make, instead make everyone's life, especially after hearing what you said about the accessory thing. It's just fucking dumb. Cops, I'll give it, the TLDR is, I sat with Turner, I sat with Peters, we went through this, and I'm like, it's a waste of good cop time. In other words, the cops that go and do all the reports and whatever, to spend like, let's say, an hour on trying to VAP a vehicle in which there is no suspect. It's only to then try to seize a vehicle that is worth dog shit. It doesn't have any societal effect. There is, I think there has been a, let's use the word, perceived notion that you might take someone's thing, you won't. That's the reality, right? Only a handful here and there. So instead, I've been advocating, and Turners to get back to me, that there should be a charge for using a vehicle that is non-local owned. You can find some better verbiage for it. In the event it is over like a certain threshold, say like maybe 800 like rating, maybe another for like 1,000 plus rating. I don't know.
You could say it's like an imported car.
Yeah, we could call it.
Like the local cars are here, and the ones that we buy from Mosley's and Tuna are all imported.
Absolutely. If it's untampered with and it was utilized in a crime, there will be the regular one charge, and then there will be the high performance one. So you just fucking hit them with that charge. And what that's going to do is it's going to migrate the notion of seizures on vehicles to this is going to be the side effect, is that if someone's drug trafficking in that, you go seize it, right? You file for it in a court case. If it's like weapons trafficking, same sort of thing. So you're making an argument that that vehicle is being inherently used for that. So moving away from, it's going to save a lot of police time. I think it's going to be good for people overall. And we'll see what Turner comes up with there with the opinions. But I think that moves things in a much better direction because do you have any?
A lighter note that there is a chicken that has a lower state ID than all of us. Look up 1001.
Sorry, say again. What is it?
There is a chicken that has a lower state ID than everyone. State ID 1001.
What the fuck is this? Henrietta Lucille Thomas.
Yeah, last night there was, a funny kind of court case where there was a chicken coop that got raided, and they were charging the chickens with weapons trafficking. Two of the chickens showed up, but got shot because they held up McNulty.
Oh, chicken.
Yeah.
What the fuck?
Yeah, there was a chicken coop with like 38 class 1s, shotguns, and a grenade in it.
And then last night, those chickens pulled guns on the cops and were blown to smithereens. Cartoon style, pretty much.
A court case where the defendant were chickens?
Chickens and the owner of the chickens.
Oh. Yep.
Yeah.
I don't think chickens have rights, no?
Well, they were intelligent enough to intelligent enough in the same way like Bongo is intelligent enough to understand things.
Bongo has a state ID, so.
Oh, interesting.
Like there was a translator there. He understood the chickens. They understood what was being said, and they answered questions.
People have now figured out that McNulty is afraid of small birds as well, which is an interesting one. But it was an interesting case.
And the thing is, a fuck you to the BCSO, the owner of the chickens the chickens that died. She went and buried them at the SDSO graves.
Yeah, that makes sense.
Yeah, that one was an interesting one, and there was some serious stuff in that court case that I don't think should have been there.
Yeah, don't want to keep you any longer. If you've got stuff you need to go take care of.
Yeah,
I'm gonna get back out there. Hey, I appreciate it, guys. You have a good day.
Take it.
You too.
Right next to Mason Dixie.